All right, buckle up for a con law deep dive, because today we're all about helping you nail that final exam.
Yeah, it's a big one.
Con law can be a beast, but stick with us, and you'll be ready to tackle those tough questions.
That's right. You've been hitting the books, and we're here to help you pull out those golden nuggets of knowledge. The stuff that'll really make a difference on your exam.
We'll hit those crucial concepts, throw in some real-world examples.
And who knows?
You might just walk away with some fun facts to drop on your professor, or at the very least, survive the exam.
Let's do it.
Okay, let's kick things off with a biggie, the Commerce Clause.
Yeah, one of the cornerstones of congressional power.
This is all about how much power Congress has to regulate economic activity.
And trust me, it's way more interesting than it sounds.
So true. So how does the court decide what Congress can actually regulate?
Well, they've set up three main categories. Think of them as Congress's power plays. First up, we've got regulating the channels of interstate commerce.
The channels, okay.
Yeah, think highways, waterways, even the internet. Basically the pathways that commerce flows through.
Makes sense. Congress needs to keep those channels open for the economy to work. What's next?
Next, you've got the instrumentalities of interstate commerce, the trucks, trains, planes, ships, and of course, the goods and people they're moving across those state lines.
So Congress gets to set the rules of the road, so to speak.
Exactly.
But there's more to it, right? What's that third category, the one where things get really tricky?
You got it. The third one is regulating activities that substantially affect interstate commerce. And this is where things get interesting because figuring out what substantially affects commerce is a whole legal battleground.
Right, substantially affecting. That seems pretty broad. How has the court interpreted that over time?
It's been a bit of a roller coaster ride. Early on, the court gave Congress a lot of wiggle room, letting them regulate even activities that maybe only had an indirect effect on commerce. But more recently, the court has become more skeptical, put some limits on what qualifies.
So if a product is moving across state lines, Congress can basically regulate it. But for things happening within a single state.
It gets a lot murkier.
Exactly. How does the court decide if something's impacting interstate commerce enough to warrant federal regulation?
Well, that's the million-dollar question, isn't it? The court looks at a bunch of things. How economically significant is the activity? Is it part of a larger national market? And is regulating it really necessary to prevent harm to interstate commerce? It's all about finding that balance.
It's a tough job. Can you give us a real-world example of how this substantially affecting thing is played out?
Absolutely. A classic example is Wickard v. Filburn.
Okay, Wickard v. Filburn, take us there.
All right, so this case involved a farmer growing wheat on his own land just for his own use. Not selling it, not trading it, just growing it for himself.
Wait, he was growing wheat for himself. How on earth did that end up in the Supreme Court?
Well, the government back then had put limits on wheat production, to stabilize prices during the Great Depression. And Filburn, he argued that growing wheat just for personal use was a local activity, said it didn't affect interstate commerce at all.
Yeah, I can see his point. What did the court say?
The court said that even though his own wheat consumption was small, if enough farmers did the same thing, it would affect the whole national wheat market, and that would undermine those government efforts to regulate those prices.
Wow, that's fascinating. So even small local actions can add up and impact the national economy. It gives Congress a surprising amount of power. I bet that case was controversial.
Oh, absolutely. It still is. It's often cited as an example of the court giving Congress a lot of power under the Commerce Clause. But it also shows just how complicated these issues are, how the court has to weigh these national regulations against individual rights and states' rights.
Okay, so we see how powerful this Commerce Clause can be. But what happens when federal law and state law clash? Who wins in that showdown?
You're thinking about the Supremacy Clause?
The Supremacy Clause, right.
It basically lays down the law, literally. It says that the Constitution, federal laws, and treaties are the supreme law of the land. Federal law trumps state law.
It's like the ultimate trump card. Why is this so important?
Well, it keeps things running smoothly. It prevents chaos, right? Imagine if states could just ignore federal laws, we'd have 50 different sets of rules and the whole system would fall apart. The Supremacy Clause, it's like the referee, makes sure everyone's playing by the same rules.
It keeps everyone in line. Can you give us an example of the Supremacy Clause in action?
A perfect example is the clash we're seeing between federal marijuana laws and state legalization. A lot of states have legalized recreational or medical marijuana, but federally, it's still illegal.
Right, because marijuana is classified as a Schedule I drug under federal law. So even where it's legal at the state level, the feds could still technically prosecute, right?
Exactly. That's the supremacy clause in action. Federal law takes precedence, even if states have gone a different direction.
That creates a really complex situation. What happens in those cases? Does the federal law just automatically overrule the state law, or is there some kind of process?
It can get messy. Sometimes the federal government, they enforce their laws, even in those states with different policies. Other times they take a more hands-off approach. It really just depends on the issue, politics, resources, a lot of factors.
So it's a constant tug-of-war between federal and state power.
You could say that.
Okay, let's move on to something that sounds a bit mysterious. The Dormant Commerce Clause. Can you shed some light on this for us?
It does sound mysterious, right? But it's vital to our federal system. Think of it like the flip side of the Commerce Clause. So the Commerce Clause gives Congress the power to regulate commerce. The Dormant Commerce Clause limits states' ability to do the same, even when there's no federal law directly on the issue.
So it's like an invisible hand saying, states, you can't mess with interstate commerce, even if there's no federal law specifically forbidding it. Why is that? Why not just let states regulate their own economies?
The main reason is to prevent states from putting up protectionist policies that would fragment the national economy. You see, the framers, they knew that if states could just erect trade barriers or discriminate against businesses or goods from other states, it would create chaos. It would really stifle economic growth.
So it's about preventing those states from becoming mini countries with their own competing economic policies.
Precisely.
It ensures that the national market can function smoothly. Can you give us a real-world scenario to illustrate this?
Imagine a state that's a big producer of, let's say, oranges. And to protect their orange growers, they try to pass a law saying that all grocery stores in the state can only sell oranges grown within that state.
That doesn't sound very fair to citrus lovers in that state, or to orange growers from other states who are now shut out of that market. Would the Dormant Commerce Clause step in and stop that kind of law?
Most likely, yes. That law would be discriminating against interstate commerce, burdening that free flow of goods across state lines.
So even though there's no federal law about oranges,
Right.
the Dormant Commerce Clause acts as a safeguard.
Exactly. It's all about maintaining a level playing field.
It's all starting to make sense. We've covered Congress's power under the Commerce Clause,
Right.
the Supremacy Clause, which says federal law is king,
That's right.
and the Dormant Commerce Clause, which keeps states from messing with interstate commerce. But Congress has another powerful tool, the power of the purse.
Oh, you're talking about the spending power.
The spending power.
Yeah.
Article 1 of the Constitution, it gives Congress the power to tax and spend for the general welfare.
For the good of the country.
But I bet there's a catch.
There's always a catch in con law. While the power to tax and spend is broad, it's not unlimited. The Supreme Court has laid down some guidelines, especially when it comes to attaching conditions to federal funds.
The classic strings attached situation. So if states want federal money, they got to play by Congress's rules. Can you give us a case where the court addressed this?
A landmark case is South Dakota v. Dole. This case dealt with a federal law that withheld highway funds from states that didn't raise their drinking age to 21.
South Dakota v. Dole. I remember that one. So South Dakota at the time, they had a lower drinking age,
Right.
argued that Congress was overreaching. What did the court say?
The court ultimately upheld the federal law, but it also set some important ground rules for when Congress can attach those conditions to funds.
Okay, what are those ground rules? What does Congress need to keep in mind?
The most important thing is that those conditions can't be coercive, meaning they can't be so burdensome that states have no choice but to comply. You know, Congress can encourage states towards certain policy goals, but they can't force them.
So it's a delicate balancing act, right?
Absolutely.
Can you give us an example of how this might play out in a real-world policy debate?
Sure. Let's say there's a debate about education policy. Congress wants to encourage states to adopt certain standards, but they can't just directly mandate those changes because education is primarily a state responsibility.
So how could they use their spending power in that situation?
They could offer additional funding to states that implement those desired policies. You know, they could set up grant programs where states can apply for funding to develop new curricula that align with those federal standards, for example.
It's a more collaborative approach.
Exactly, encouraging states to cooperate, not forcing them.
Okay, speaking of checks and balances, collaboration, We can't forget one of the most fundamental cases in American con law, Marbury v. Madison. This case is all about who gets the final say when it comes to the law of the land.
That's right. Marbury v. Madison, this is like the ultimate power move for the Supreme Court.
I've heard the name, but I'm a little fuzzy on the details. Can you set the stage for us?
It's 1803. We've got a new president, Thomas Jefferson, who had just defeated the incumbent Federalist, John Adams. But before leaving office, Adams went and appointed a bunch of Federalist judges, including this guy, William Marbury, as a justice of the peace.
Classic last-minute political appointments. I bet Jefferson wasn't thrilled.
He was not. So Jefferson takes office, and he tells his Secretary of State, James Madison, to basically withhold Marbury's commission, preventing him from taking the job.
What does Marbury do?
Marbury went straight to the Supreme Court. He asked them to issue an order forcing Madison to deliver that commission.
So the court, what did they do? Did they side with Marbury?
This is where it gets really interesting. The court, led by John Marshall, they were in a tough spot.
I can imagine.
They wanted to assert their authority, but they didn't want to just directly challenge the president and risk this whole constitutional crisis.
That's a recipe for disaster. So what was their solution?
They came up with a brilliant strategy. They found a way to side with Marbury in principle, but avoid a direct confrontation with Jefferson. They ruled that Marbury did have a right to his commission, but they also ruled that the law giving the court the power to issue the order was unconstitutional.
Yo, hold on. So they said, you're right, Mr. Marbury, but we can't help you because the law that would let us do so is invalid. That's a bold move.
It was. And it established a fundamental principle: judicial review.
Judicial review.
Yep. Marbury v. Madison, it gave the courts the power to declare laws unconstitutional. It's power they still hold today, and it's something you'll definitely want to understand for that exam.
So Marbury v. Madison, it set the stage for the Supreme Court to be the ultimate referee when it comes to deciding whether laws are constitutional. But how do they actually make those decisions?
That's a great question. The court uses different levels of scrutiny, or standards of review when deciding if a law is constitutional. Think of it like a sliding scale of how closely they're going to examine the law and the government's reasons for having that law.
So it's not a one-size-fits-all approach. Some laws get more scrutiny than others. Tell me more about these levels of scrutiny.
You got it. There are 3 main levels of scrutiny: rational basis, intermediate scrutiny, and strict scrutiny. Which one the court uses depends on what kind of right is affected by the law and how the law classifies people.
Let's break those down. What's the most basic level?
The most lenient standard is the rational basis test. Basically, a law is presumed to be constitutional as long as there's some rational basis for it, meaning the government can show it's reasonably related to a legitimate government interest. It's a pretty low bar to clear.
So if the government can come up with a plausible reason for the law, it's likely to pass. What kind of laws fall under that?
Most laws regulating economic activity or social welfare programs fall under rational basis review. The court generally defers to the legislature's judgment in these areas.
Okay, so what about that next level up? Intermediate scrutiny.
Intermediate scrutiny, it's a bit tougher. The law has to be substantially related to an important government interest. This means the connection between the law and its objective needs to be stronger.
So the government can't just have any old reason. It needs a pretty significant reason for the law. What kind of laws get this level of scrutiny?
Laws involving gender discrimination, regulating commercial speech, or restricting certain fundamental rights usually get intermediate scrutiny.
Okay, we've gone from rational basis, which is pretty easy to pass, to intermediate scrutiny, which is tougher. Now, strict scrutiny, that sounds serious. When does the court use that one?
Strict scrutiny, that's reserved for laws that affect fundamental rights or involve what we call suspect classifications.
Suspect classifications, what are those?
Suspect classifications are those categories that have historically been subject to discrimination. So we're talking race, national origin, alienage.
Okay, so if a law restricts free speech or treats people differently based on their race, it's going to face the toughest scrutiny. What does the government have to prove in those cases?
They've got to prove that the law is narrowly tailored to achieve a compelling government interest.
That sounds like a high bar to clear. They can't just have a good reason.
Right. It has to be absolutely essential, and there can't be a less restrictive way to achieve that same goal.
It's like those levels of difficulty in a video game, right?
Aha! I like that.
Rational basis is easy, intermediate scrutiny is harder, and strict scrutiny is the boss level.
That's a great analogy. The level of scrutiny, it really determines how tough it will be for the government to defend their law.
Okay, so we've got Congress making laws, Supreme Court reviewing them, and this whole system of scrutiny levels to determine if they're constitutional. But what happens when Congress decides to delegate some of its power to other entities? You know, those alphabet soup administrative agencies. Does that raise any constitutional issues?
It sure does. That's where the non-delegation doctrine comes in. It's all about making sure the right branch of government is doing its job.
Okay, so Congress can't just hand off its lawmaking power to someone else without any rules.
Exactly. The Constitution gives Congress the power to make laws, and the non-delegation doctrine says they can't just give that power away. The court has said Congress can delegate some authority to agencies to carry out laws, but they have to give clear instructions and limitations.
They can't just say, go make some laws about this topic. They have to give them specific directions.
Right, exactly.
Why is this so important? What's the big deal about Congress delegating power?
It's all about accountability. We need to make sure the people we elect to Congress are the ones making the big decisions. If Congress could just delegate its legislative power all over the place, it would undermine the separation of powers. We could end up with unelected bureaucrats running the show. The non-delegation doctrine is a safeguard against that.
So it's all about keeping the power to make laws with Congress where it belongs. But doesn't Congress need help sometimes from experts?
Oh, absolutely.
How do we balance that need for expertise with this principle of keeping lawmaking power with Congress?
That's a great question, and it's one that courts and legal scholars are still debating. It's about finding that balance between giving those agencies the flexibility to do their jobs effectively and making sure Congress ultimately retains control over lawmaking.
It's a tricky one. All right, let's do a rapid-fire round of other essential con law concepts that are guaranteed to be on your exam. Ready to play ball?
Give me a bit.
All right, first up, standing. What does someone need to show to even get their case heard in federal court?
They have to show they've been harmed, in a way that a court can actually fix. You can't just sue because you're upset about something. You need to have a real injury that's directly related to what the defendant did.
It's like a ticket to get into the courtroom.
Exactly.
What about preemption? We talked about the supremacy clause, but I know there are different types of preemption, right?
You're right. There's express preemption, which is where Congress explicitly says, federal law overrules state law in a certain area. Then there's field preemption, where federal law is so comprehensive it covers the whole field, leaving no room for state regulation. And then there's conflict preemption, where it's just impossible to follow both federal and state law at the same time.
Okay, so no matter how you slice it, federal law wins in a clash with state law.
Yep.
What about the anti-commandeering doctrine? That one always trips me up.
The anti-commandeering doctrine, it prevents the feds from forcing states to run federal programs or enforce federal law. States are sovereign entities. The feds can't just boss them around.
So the feds can't just say, hey, states, enforce this new federal law for us. They have to respect the state's authority.
Yeah.
But how do we balance that with this idea that the federal government needs to be able to enforce laws uniformly across the country?
It's another one of those tricky balances, right? It highlights that tension between federal power and state sovereignty that is at the heart of so many con law debates.
It's a constant push and pull.
Yeah.
Okay, we've blazed through a lot in this rapid-fire round, but before we wrap up this part of our cram session, let's talk about some landmark cases and constitutional amendments guaranteed to be on your exam. You ready for some con law greatest hits?
I was born ready. Let's do it.
All right. First up, McCulloch v. Maryland.
Ah, a classic.
This case is all about the necessary and proper clause and that concept of implied powers.
Right, McCulloch, it was all about whether Congress could create a national bank. The Constitution doesn't specifically mention banks, but the court said Congress could do it because it was a necessary and proper way to carry out other powers, like regulating commerce and collecting taxes.
So it broadened the power of the federal government by saying that Congress isn't limited to just the things specifically listed in the Constitution.
Exactly.
That's a big deal. What about U.S. v. Nixon? Executive power.
U.S. v. Nixon, that one came from the Watergate scandal, right? It dealt with President Nixon's claim of executive privilege to keep those Oval Office tapes secret during the investigation.
So he was basically saying, I'm the president, I don't have to hand over these tapes. Did that work?
Well, not quite. The court said that, yes, executive privilege exists, but it's not absolute. It has to yield to other important interests, like the need for evidence in a criminal trial.
Even the president isn't above the law. What's another important Commerce Clause case we should know?
Heart of Atlanta Motel v. U.S. Can't forget that one. This case involved the Civil Rights Act of 1964, which prohibited racial discrimination in places of public accommodation, which included hotels. The Heart of Atlanta Motel challenged the law, arguing that Congress couldn't regulate their business because it was a local matter.
So they were saying that who they served didn't affect interstate commerce.
Right.
Did the court buy that argument?
Not at all. The court said that Congress could regulate racial discrimination under the Commerce Clause because it had a big impact on interstate travel. This was a huge win for the civil rights movement because it proved the Commerce Clause could be used to address social issues with national implications.
Powerful stuff. Now, let's not forget about those powerhouse constitutional amendments.
You're talking about the big three.
The big three. The 13th, 14th, and 15th Amendments, the post-Civil War trio that reshaped America.
Absolutely.
Let's quickly remind our listener about each one, starting with the 13th Amendment.
The 13th Amendment abolished slavery. Plain and simple. No more involuntary servitude except as punishment for a crime. A monumental step towards equality and justice.
And the 14th Amendment?
The 14th Amendment, that's one of the most important and most litigated parts of the Constitution. It's got the Equal Protection Clause and the Due Process Clause. Equal protection means states can't deny anyone the equal protection of the laws, and due process limits the government's power to take away life, liberty, or property without fair procedures.
So the 14th is all about ensuring everyone is treated equally under the law and protecting those basic rights. And what about the 15th Amendment?
The 15th Amendment, it guarantees the right to vote regardless of race, color, or previous condition of servitude. It was a critical step towards voting rights for African Americans after the Civil War.
Those three amendments really revolutionized American society.
Wow, we have covered a lot of ground in this first part of our con law cram session.
We have.
And there's still so much more to explore. But I think our listeners are ready for a well-deserved break.
Don't go anywhere, listener. We'll be back with even more con law concepts to help you dominate that exam. Welcome back to our con law deep dive. Ready for round two? We've got even more key concepts and landmark cases to prep you for that exam.
Let's jump right in. Still so much to cover.
Okay, let's pick up where we left off, the Dormant Commerce Clause. Remember, it's all about limiting states' power to mess with interstate commerce. But there's a twist. It's called the market participant exception. It's kind of like a loophole lets states act like regular businesses sometimes.
Yeah, exactly. This exception allows states to give preference to their own businesses in certain situations. Usually comes up when a state is acting as a buyer or seller of goods or services rather than a regulator.
So it's like the Dormant Commerce Clause takes a break. States get to flex their economic muscles a bit. Can you give us an example?
Sure, imagine a state is building a new highway. They need a lot of concrete, right? They might decide to give preference to local concrete companies, even if companies from other states are offering lower prices.
But doesn't that seem unfair to those out-of-state companies? Wouldn't it cost taxpayers more? How does the court justify this exception?
The reasoning is that when a state is acting as a buyer, just like any other business, they should have the freedom to choose who they do business with. Of course, this doesn't mean states have a free pass to discriminate. The court has set some limits on how far states can go with this exception.
It's all about finding that balance.
Always is.
Between letting states have some economic control and preventing them from creating barriers to interstate commerce. Tricky stuff. But speaking of tricky legal battles, let's get back to those landmark Supreme Court cases. Gibbons v. Ogden, a Commerce Clause showdown from way back in 1824.
Gibbons v. Ogden, a classic. This case really laid the groundwork for the broad power Congress has to regulate commerce.
Okay, I'm all ears. What was the drama all about in Gibbons v. Ogden?
It all started with the steamboat monopoly. Robert Fulton and Robert Livingston, they had been given exclusive rights by New York to operate steamboats on waters within the state.
Wow, a steamboat monopoly. Talk about controlling the waterways. Who challenged this?
Thomas Gibbons did. He had a federal license to operate steamboats under a law that regulated coastal trade. So he decided to compete with Ogden, argued that the federal law superseded New York's monopoly.
Classic showdown. State versus federal authority.
Exactly.
What did the Supreme Court decide?
The court sided with Gibbons. They said that the power to regulate interstate commerce, it belongs to Congress. States can't make laws that conflict with federal law in this area.
Another win for the feds. Why is this case still so important today?
Well, Gibbons v. Ogden, it really broadened how we interpret Congress's power under the Commerce Clause. It also affirmed that federal law trumps state law when it comes to interstate commerce, set the stage for a more powerful national government, and helped define that balance of power.
Amazing how these old cases still have such a huge impact on us today. But it's not just about the powers of Congress or the federal government. The Constitution is also about protecting individual rights. And one of the most important provisions for that is the Equal Protection Clause. It's been at the center of some of the biggest legal battles in American history, hasn't it?
Absolutely. The Equal Protection Clause, it's a cornerstone of our Constitution. It guarantees that everyone's treated equally under the law, and it's been incredibly important in the fight against discrimination, the advancement of civil rights.
And it's not just about race, right? Even though the 14th Amendment, which includes the Equal Protection Clause, was passed after the Civil War to address racial discrimination, it's much broader than that. The Equal Protection Clause has been applied to all sorts of groups and situations over the years.
That's right. The Equal Protection Clause, it's for everyone. But figuring out what equal protection actually means in real life, that's complex. The Supreme Court has had to tackle so many cases to figure out when laws violate the Constitution and when they don't. We're talking school segregation, affirmative action, same-sex marriage. The list goes on.
So how does the court decide if a law violates the Equal Protection Clause? Do they use those levels of scrutiny that we talked about earlier? Rational basis, intermediate scrutiny, and strict scrutiny.
They do. Which level of scrutiny gets applied depends on what kind of classification is being challenged, how the law distinguishes between different groups of people.
Okay, remind our listener how they figure out which level to use.
All right, so remember that rational basis review is the most lenient. That gets used for most laws, and the government just has to show that the law is reasonably related to some legitimate government interest. It's a pretty low bar to clear.
So the government has a reasonable justification. The law will probably pass. What about intermediate scrutiny?
Intermediate scrutiny is used for classifications like gender or illegitimacy, things that the court calls quasi-suspect classifications. The government has to show a substantial relationship between the law and an important government interest. It's tougher than rational basis, but not as strict as strict scrutiny.
And then we've got strict scrutiny, the toughest one, reserved for classifications based on race, national origin, or alienage, or for laws that infringe on those fundamental rights.
Right. Under strict scrutiny, the government, they have to prove that the classification is absolutely necessary. It has to be to achieve a compelling government interest, and they have to show it's the least restrictive way to achieve that goal. It's a high bar to clear, and honestly, most laws that get this level of scrutiny are struck down.
Sounds like the court is very careful when it comes to laws that treat people differently based on things like race or national origin. Can you give us an example of a case where the Equal Protection Clause was front and center?
Of course. Can't talk about the Equal Protection Clause without mentioning Brown v. Board of Education. That landmark case declared those separate but equal schools for Black and white students unconstitutional.
Everyone knows about Brown v. Board, but it's easy to forget how groundbreaking it was. Remind our listener about what the case was about and what the court decided.
Sure. So Brown v. Board challenged the separate but equal doctrine that came from Plessy v. Ferguson.
Separate but equal. It sounds good on paper, but
in reality, not so much. The Supreme Court in Brown finally recognized that separating students by race creates unequal opportunities, and it violates the Equal Protection Clause. That decision was a huge turning point for the civil rights movement. It ended legal segregation in education and paved the way for desegregation in other areas of life.
What a powerful example of the Constitution in action, bringing about real social change. But let's shift gears for a minute. We've talked about individual liberties, but what about economic liberties? The right to work, make contracts, run a business without the government interfering.
That's a great point. Economic liberties are a big part of con law, too. The Constitution doesn't specifically say we have a right to economic freedom, but some provisions have been interpreted to protect these freedoms.
So there are some protections for our economic activities, even though they might not be as explicitly spelled out. Where do we find those?
The Due Process Clause of the 14th Amendment has been really important in shaping how we think about economic liberty. Specifically, the idea of substantive due process. It basically says the government can't infringe on fundamental rights, even those not specifically listed in the Constitution, without a really good reason.
So the government can't just mess with our economic freedoms for no reason.
Exactly.
What kind of activities have been protected under this?
The court has recognized things like the right to contract, the right to pursue a lawful occupation, and the right to own and use property. Now, these aren't absolute rights, but they do place some limits on how far the government can go in regulating economic activity.
So the government wants to pass a law that restricts what jobs people can have or that heavily regulates businesses. It can't just do it on a whim. What level of scrutiny is used in these cases?
Usually rational basis review. The government just has to show that the law is rationally related to a legitimate government purpose.
Not the strictest standard, but at least it provides some protection. Can you give us an example of a case about economic liberties?
One very famous or infamous case is Lochner v. New York. It's from 1905, and it's all about bakers and how many hours they can work.
Lochner, I've heard of that one. What happened?
Lochner involved a New York law that limited the number of hours bakers could work. The Supreme Court struck it down, saying it violated the baker's freedom of contract.
The court sided with the bakers who wanted to work longer hours. That seems a bit odd.
I know, right? Seems counterintuitive today, but this case took place during the Lochner era. It was a period of about 30 years where the court often struck down laws that regulated working conditions in businesses. It was a very hands-off approach to the economy.
So basically, the court back then thought the government should just stay out of the economy and let businesses do their thing.
Exactly, a very laissez-faire approach. But that changed during the Great Depression. After seeing what happens when you have an unregulated economy, the court became much more accepting of government regulation.
It makes sense. Sometimes you need the government to step in and stabilize things, especially during a crisis. So what about today? How does the court view these economic liberties now?
They've moved away from that super hands-off approach of the Lochner era. Now they usually use that rational basis review for economic regulations, which means the government has more leeway.
So the court still recognizes the importance of economic liberty, but they're also more willing to let the government regulate the economy for the public good. Okay, let's turn to another big aspect of congressional power, the taxing power. We touched on this a bit when we talked about spending power, but it's a big topic that needs its own attention.
Definitely. It's how they get the money to do everything else.
So Congress gets to decide how to fund all those government programs and activities. Sounds straightforward, but I'm sure there's more to it.
Oh, there's always more to it in con law. There's some limits to this power, for sure.
I knew there had to be a but coming. What are the limits? What are the rules of the road when it comes to taxes?
First, taxes have to be for a public purpose. Congress can't just raise money to give to private companies or individuals.
The government can't tax people just to make a few people rich. The money has to be used to benefit everyone.
Right. Another rule is that direct taxes, like income taxes, have to be apportioned among the states based on population. So, states with more people contribute more.
Makes sense. It's all about fairness. More people, more tax dollars. What about indirect taxes, like sales taxes? Do those have to be apportioned too?
Nope. Indirect taxes, they don't have to be apportioned. Congress has more flexibility with those. But they have to be uniform throughout the U.S., so no different rates in different states.
No playing favorites. It sounds like they have a lot of power, but they also have to follow the rules.
They do.
Can you give us a case where the court had to deal with those limits on the taxing power?
A really important one is National Federation of Independent Business v. Sebelius, the Obamacare case.
Oh yeah, Obamacare.
It involved a challenge to the Affordable Care Act's individual mandate. The part that required most Americans to have health insurance or pay a penalty.
The individual mandate, that was a big deal. How did the court view the mandate in terms of the taxing power?
They upheld the individual mandate, but not for the reasons the government argued. They basically said that penalty for not having insurance, it was a tax, and Congress had the power to create it under the taxing power.
So even though the law called it a penalty, the court said it was a tax in disguise.
Exactly. The court pointed out that the penalty was collected by the IRS and it functions like a tax. They decided it was a valid use of the taxing power, even if its primary purpose wasn't raising revenue.
That's really interesting. It shows how the court can be flexible when they're interpreting the Constitution. Okay, let's turn our attention to the spending power, the other side of Congress's financial authority.
It's like the taxing power's partner in crime.
Right. Congress has the power to tax, but it also has a lot of power to spend that money for the good of the nation. But there have to be some rules, right? Can you break down those rules for our listener?
Well, the spending clause itself is pretty straightforward. Congress has the power to pay the debts and provide for the common defense and general welfare. Figuring out what that means in practice has kept everyone busy for a long time.
It does sound like a lot of wiggle room. So how has the court interpreted the spending power over the years?
Generally, they've given Congress a lot of leeway. They've acknowledged it includes a wide range of things that could promote the general welfare. But remember South Dakota v. Dole, that case we talked about?
I do.
The court said that Congress can't use its spending power to coerce states into adopting policies they wouldn't otherwise have to.
Right. It can't be a do this or you lose all your funding situation. But can they incentivize states, offer some rewards or benefits to encourage them to go along with certain policies?
That's a great question, and it's actually at the heart of a lot of debate about the spending power right now. The court has said that conditions attached to federal funds have to be clearly stated. They have to relate to the purpose of that spending, and they can't be so burdensome that states really have no choice but to comply.
It's like a delicate dance. Congress can encourage states to follow their lead, but they can't be too heavy-handed. Can you give us an example?
Absolutely. Let's say Congress wants to encourage states to invest in renewable energy sources. They can't force them to, but they could offer grants or funding for infrastructure projects to states that choose to invest in solar or wind power.
It's like a you scratch my back, I'll scratch yours
In-
approach. Encourages cooperation.
Exactly. It's all about finding that sweet spot where Congress can use its spending power to achieve national goals, but also respect the state's sovereignty.
Another example of the Constitution as a living document, right? It creates that framework for governing, but it leaves room for interpretation, debate, allows it to adapt as things change. Okay, let's take a quick break. We'll come back and wrap up with some final key concepts. Okay, we're back for the final round of our con law cram session. We've covered a lot of ground, but we're going to finish strong with a few more key concepts, ready to make sure you ace that exam.
Let's do it. I think our listeners are ready.
All right, let's dive into some of the ways the Constitution limits government power. The stuff that protects your individual rights. We've talked a lot about what Congress and the federal government can do, but the Constitution is also about making sure they don't step on our freedoms.
Absolutely.
Yeah.
It's all about balance. And one of the most important principles that keeps the government in check is the doctrine of enumerated powers.
Okay, the doctrine of enumerated powers. What's that all about?
It means the federal government can only do the things the Constitution specifically says it can do. If it's not on the list, it's left to the states or to the people.
So it's like a permission slip. Where do we find this list?
Mostly in Article 1 of the Constitution, that outlines the powers of Congress: regulating commerce, declaring war, coining money, establishing a post office.
It's their to-do list.
You got it.
But what happens if they try to do something that's not on that list? Who decides if they've overstepped?
That's where the courts come in. It's their job to interpret the Constitution and make sure everyone is following the rules.
So if Congress passes a law that seems to go beyond those enumerated powers, someone can challenge it and the courts will decide.
Yeah.
It's all about checks and balances, right?
Exactly. It keeps any one branch from getting too powerful.
Now, what about the 10th Amendment? That's the one about states' rights, right?
Yep. The 10th Amendment is short, but it's powerful. It says any powers not given to the federal government are reserved for the states or the people.
So it really reinforces that idea of enumerated powers.
It does. If it's not a federal power, it belongs to the states.
A major win for states' rights.
Exactly. It's a key part of our federal system. Ensures that the states have a role to play and that the federal government can't just dictate everything.
But I'm guessing it's not always easy to figure out where that line is between federal and state power. It must lead to a lot of disagreements.
Oh, for sure. The 10th Amendment has been at the center of so many legal battles, and it's still so relevant today. It shows us that that balance of power is constantly changing, something we have to keep working on.
It's a balancing act, for sure. The feds need to address national issues, but states need to be able to govern themselves, too. Speaking of states, let's talk about a clause that protects individuals when they're moving between different states. The Privileges and Immunities Clause.
The Privileges and Immunities Clause, it's in Article 4, and it says citizens of each state, they're entitled to the same privileges and immunities as citizens of other states.
So no matter what state you're from, you should be treated fairly in other states.
Exactly. You shouldn't be treated as a second-class citizen just because you're from out of state.
Makes sense. Can you give us an example?
Sure. Imagine you're from Texas. You're visiting California.
All right, I'm in California.
The Privileges and Immunities Clause means California can't deny you those basic rights and privileges that they give to their own residents. You have the right to travel freely throughout the state, use their roads and parks, even access their courts.
So they can't kick me out just because I'm not from California.
Right. They have to treat you like a resident, at least when it comes to those basic rights and privileges. Now, there are some exceptions, like states can have residency requirements for voting or in-state tuition.
That makes sense. You can't expect residents to pay for services for folks who don't even live there. But overall, it's about making sure we're all treated equally, no matter where we're from.
Exactly. It helps create a more unified country. But there's one more clause we should talk about. It's all about making sure our legal system works smoothly between the states.
Yeah.
The full faith and credit clause.
Okay. The full faith and credit clause. Lay it on me.
This clause says that states have to respect each other's laws and judicial decisions. Like, a couple gets married in Massachusetts, they move to Alabama. Alabama has to recognize that marriage as valid, even if they wouldn't have allowed the marriage to happen in their state in the first place.
So no need to get remarried every time you move to a new state.
Right.
But are there any times when a state might not have to recognize another state's laws or judgments?
Yeah, there are exceptions. The big one is when the law or judgment violates the public policy of the state where it's being invoked. So if one state has a really strong policy against something and another state allows it, they might not have to enforce it.
So it's a way for states to protect their own values and interests, even if it creates some tricky legal situations. How does the court decide when one state's public policy is strong enough to override this clause?
Well, it's not easy. It's a case-by-case thing, trying to balance the interests of both states.
Makes sense. Well, we have covered an incredible amount of con law in this cram session, from the powers of Congress and the limits on those powers, to the importance of protecting individual rights and making sure things are fair and consistent across our legal system.
It's been a whirlwind tour of the Constitution.
It has. And I know our listener is ready to tackle that exam. You've got the knowledge. Now go out there and crush it. But before we sign off, I want to leave you with a final thought-provoking question. We've talked about how the Constitution divides power between the federal government and the states. But what happens when those powers collide? Who ultimately gets to decide? Is it Congress, the president, the courts, or at the end of the day, the people?
That's a great question. It really gets to the heart of what con law is all about, figuring out how to make this system of government work. And the answer, it's complicated. The balance of power is constantly in flux. And it's up to all of us to think critically about how we interpret and apply the Constitution and the world we live in today.
That's it for this deep dive into con law. Keep those brains buzzing, keep asking questions, and good luck on those exams.